May I please lodge?
Yes.
Lordship, item number 17. I'm for the petitioner. I'm here to file a reply to the every filed by the state government. Kindly allow me to fix that.
3 weeks.
Yes, item 17.
Learned counsel, Mr. Fuseko, appearing for the petitioner, has prayed for 3 weeks' time to file a reply to the affidavit in opposition filed by the state respondents. Mr. Prayer is allowed, list the matter up to 3 weeks.
Hello, bhai.
Yes. Lordship, subject to repetition, I may have to refer to some of the documents relied upon by my learned friend
Hmm.
to highlight the facts. Lordship, extraordinary situation demands extraordinary action by the government, and which requires extra special consideration. Now, kindly allow me to refer to my affidavit, because I have annexed all the relevant documents which my learned friend has referred, so that it will be easier for me. Respondent 19 to 33, 25 to 101.
Yes.
Lordship, kindly allow me to refer to page 13, annexure 1. I hope it is not the affidavit.
Oh,
It will be a little thicker one.
oh, children, that's why I thought. This 4-2. 24. Okay, okay. I got it. 19 to 23,
Yes.
25 to 101.
Yes. Lordship, during the COVID pandemic, the state cabinet took several important policy decisions, and I have enclosed all those documents so that Lordship understood the issue in the right perspective. Now, may I go to page 13, annexure 1, type copies in page 14.
Yes.
Lordship, the cabinet decision on 30th March
30th March
2020,
2020.
serial number 3 and 4.
Serial number
3 and
3
4.
and 4.
The decision on 30th March, the department will be authorized to engage medical personnel as the need arises, strength for a fixed period to tide over the crisis. For all such appointments and engagements of medical personnel should be done in a transparent manner on strict terms and conditions to avoid further complications. So this was the first decision. Then, not sure. Next page, page 15. Lordship, by decision of the government on 22nd April 2020, all the appointments, all fresh appointments in other departments were freezed, except the medical department. Just to
Yes.
then, Lordship, annexure 3, page 16. The cabinet meeting held on 1st June 2020. My learned friend has referred to this, and Lordship, that is, the state government had, my lord, at page 17. The requirement of medical personnel like doctors, nurses, etc. were agreed in principle. The formal proposal will be submitted by the department for approval of the competent authority. In other words, not just the requirement, what is the requirements to tide over the COVID? Direction was by the cabinet for submission of the proposal by the concerned departments. Accordingly, Lordship, at page 18, 12 June, memorandum on 11th of June, it was approved. Lordship, to save time, I'm only kindly allow me to refer to paragraph page 19, the last subparagraph. The cabinet further directed that this approval is a one-time relaxation of laid down rules and procedures. Lordship, it is laid down rules and procedures. Page 19. For recruitment, regularization, and continuation of age. Further, this one-time measure is in view of prevailing situation and backdrop of COVID-19 pandemic shall not be treated as a precedent. So, Lordship, twofold, relaxation of rules, service rules and procedures. That is procedures for recruitment. For procedures for recruitment, Lordship, they kindly appreciate this fact. Lordship,
Laid down.
one-time relaxation of laid down rules, one, and procedure for recruitments, comma. So procedures for recruitment, regularization and continuation of age.
Recruitment, regularization, and continuation of age.
So, Lordship, rules were relaxed and procedures to conduct normal procedures for recruitment was relaxed, and rules and procedures are regularized for not only for the purpose of recruitment, it is also for regularization and continuation of age. In fact, Lordship, as stated in the advertisement, the age was condoned up to 45 years.
45.
Presently, at that moment, I thought it was only 35. And this memorandum of 12th June 2020 is not challenged. Madam Petitioner. Then, Lordship, 25th June 2020, the next page, at page 20, Annexure 5. Lordship, now the second cabinet meeting held on 23rd June 2020. Now, Lordship, creation of post, Lordship is 44 posts of medical officers. Lordship, may kindly take note of the fact that serial number 4, creation of 3 posts of junior dental surgeon, Lordship, which I will refer later stage. So, Lordship, may kindly take note of this 3 posts of junior dental surgeon. Serial number 6, creation of 6 posts of research scientist. This is petition 307, which is item number 34.
So by this same memorandum, dental surgeons were 3 posts,
Yes,
and research scientists 6
Yes.
posts were also created.
yes. Once you look into this, the other case 34, the substantial factual solutions will be done. Then, Lordship, page 21. My learned friend has read, but I would like to read A and B. The newly created post should be filled up by Health and Family Welfare Department within a month's time with proper advertisement. While filling up the post, due weightage should be given to the marks obtained by the candidates in the qualifying degree and years of work experience. The interview panel should include independent experts from outside the state. The department should clearly indicate that these appointments would be temporary and regular recruitment should be conducted through special NBSC recruitment drive. Lordship, it is special NBSC recruitment drive, not normal. The word special, Lordship, you can take note of that. Then, Lordship, page Then, Lordship, next page, page 22. Then the creation of post, Lordship, is given 44 medical officers.
medical
Then serial number 4, 3 dental surgeon. Then 5, 6 research
scientist.
scientist. So the posts were created.
Mm.
Then Lordship may kindly see next page, page 23. Thereafter, Lordship, the department principal director has submitted a letter to the government on 21st July 2020. May I read, Lordship?
Hmm.
My lord, in connection with this office letter dated such and such, the Department of Middle Officers had discussion with NPSC on 21/7/2020. I am submitting here with the outcome of a meeting for consideration of and further perusal. The NPSC cannot conduct recruitment outside the established system unless necessary direction is given by the Union Department based on the cabinet decision of one-time dispensation for relaxation of late-term rules and procedures for recruitment, regularization, and condonation of age through a special recruitment drive in view of pandemic's prevailing situation in the backdrop of COVID-19 pandemic. Therefore, the government may consider to include the following the direction for conducting a special recruitment for NPSC based on cabinet decision of 2020, such as and such is one, to do away with written examination to include legal voice, terms and conditions suggested in the earlier letter mentioned above. So a proposal was submitted. Accordingly, Lordship, next page, at page 24, the advertisement was issued on 4th August 2020 for 168 medical officers, Lordship, and for 6 posts of research scientists, 2 and 3. Then, my lord, the Lordship may kindly see at page 26. The eligibility criteria relaxation is of age up to 45 years is given. And Lordship, mode of recruitment process at page 27 is given. And Lordship, other conditions is given in page 29. Lordship, may kindly see page 29, the other conditions. There shall be the following condition will be obligatory for all selected candidates, shall not be entitled for study leave for a period of 2 years, shall serve in any part of the state as assigned by the department, shall sign a bond not to engage in private practice. The selected candidate shall report to the controlling officer within 7 days from the date of appointment order. Failure to join within the stipulated time will forfeit the appointment. Thereafter, Lordship, at page 30, the board were constituted and examination was conducted, and the appointment orders is from page 31 to Lordship, page 31 to 35. My learned friend has already referred, whereby Lordship, the respondent number 19 to 101 were appointed against the equity. So, Lordship, firstly, the appointment of respondent number 19 to 101, it is not a backdoor appointment. We were appointed through an advertisement. And as by relaxing the rules. Now, Lordship, when the advertisement was issued in the year 2022, only the petitioner
2020.
advertisement, yes, advertisement was issued in the year 2020, 4th August 2020. Lordship, only the petitioner number 1, 11 and 55 were qualified doctors. Not denied by the respondents in your affidavit.
Only petitioner 1.
1, 11, 55. And the rest were medical students. He did not possess the requisite qualification on that day when the advertisement was issued. When the advertisement for 2020 was issued. And for reasons best known, respondent number 1, 11, and 15 did not fall to the duty of humanity. Only after everything became normal, now they are challenging. Lordship, on the maintainability, I'll come at another stage. After completing the facts, I will be reiterating on the maintainability, but Lordship may kindly take note of that. Lordship, for your Lordship information, I had personally interacted with my clients. Some of them, during the 100 days COVID, during the COVID period, some of them were infected even up to 3 times by COVID, and some of them nearly died. So it is like a warlike situation where he sacrificed their lives. And also a commitment was there by the government that you served and will give you special consideration. That commitment was also there. So the question of legitimate expectation was there for the petitioner, respondent then. And to do your commitment, the department in the state government fulfilled by giving the special recruitment. Now, Lordship, page 36. This is the Cabinet Memorandum of 13 May 2022. Learned friend has referred to it, but then Lordship, to save time, I'll only read paragraph 4. In consultation with the PNR department, it is now been decided to relax the recruitment rules as a one-time measure for a special NPS recruitment drive for medical officers, junior dental surgeons to be recruited through Nagaland Health Service Rules 2006, nurses, Nagaland Service Rule 1988, medical officers, research scientists as follows. Rule such and such of the Nagaland Public Service Rules as amended from time to time for selection to be based on written examination and interview with letter constituting the 12.5 of the written examination in relaxation of the prescription for special drive. It is proposed that the selections be based on the following. The weightage is given. The manner in which weightage for COVID duty and work experience would be given. Contractual employees under the such and such who have resigned during the course of pandemic or refuse to accept the contractual agreement will not be eligible. Relaxation of maximum age for eligibility as prescribed under rules of 2006 and the corresponding rules for others up to 45 years for serving staff who have been serving. And then Lordship, 5, the PNR has conveyed clearance for the examination of interview scheme by such and such for continuation of age of 45 years. So Lordship, then Lordship may kindly see at page 38, 44 medical officers, junior such and such, research scientist 6. So Lordship, proposal was relax the rules and procedures was reiterated again by this cabinet memorandum. Then Lordship, page 40. The cabinet decision on 25th May. The undersigned is directed to forward herewith an extract copy of the minutes of the cabinet meeting held on 25th May 2022 for kind information and necessary action. Relaxation of recruitment rules for special recruitment of healthcare workers. Lordship, it is relaxation of recruitment rules for special recruitment of healthcare workers. It does not talk about whether it should be through NPSC departmentally. It is only talking about relaxation of the rules for special recruitment. And thereafter, Lordship, next page. Merit. It is dated a notification dated 2nd November 2022. Date is given in page 42. In the interest of public service and on the approval of the cabinet, 26/5/2022, the governor of Nagaland is pleased to notify the following posts to be recruited through a special recruitment drive as indicated below. One of the following posts to be recruited through a special recruitment drive. Then junior medical officers 96. Then Lordship junior dental surgeon 5. Research officers 6. Then Lordship 2. The special recruitment drive to be conducted by the NPSC. Then maximum age relaxed, such and such forth. I'm not repeating. Lordship, this notification was subject matter of litigation before this honorable court.
This
Notification dated at Annexure 16.
2/11/2022.
Lordship, I'm compiling, I'm submitting all the judgments which I would like to rely. But what first thing first, when the document is referred, I would like to by the research by the junior dental surgeons. Lordship, may kindly see at page 22, subsequent repetition, Lordship, may kindly go back to page 22 once. For junior dental surgeon, at serial number 4, only 3 posts was created.
Yes, 3 posts.
But here, in serial number 4, it is shown as 5.
Yes.
Now, some qualified medical the dental surgeons had filed the WPC 36 of 2023, Lordship.
36 of 2023.
36 of 2023. Lordship, on the top, it's real. I have indexed both the single bench judgment as well as division bench. So, your Lordship, on the top, it is WPC 36 on the top. If Lordship, you kindly open that one first. Yes, thereafter, Lordship, you kindly come back to 1. Now, Lordship, you kindly see the prayer. Paragraph 2. The writ petition has been filed inter alia seeking for a following relief. Washing set aside notification dated 2/11/2024 insofar as it concerns the post of junior dental surgeon. We direct the state respondents to fill up the 5 posts of junior dental surgeon through Nagaland Public Service Commission, strictly in accordance with Nagaland Health Service Rule 2006. Lordship, the prayer is identical. The petitioner is also praying that Wash and set aside the special recruitment drive and conduct the examination in terms of the rule through NPS. Now, Lordship, you can see paragraph 5. Paragraph 5. In view of the submission, in view of the submission made by the Learned Counsel for the parties, the present writ petition is disposed of with the direction to the spread respondents, more particularly the respondent number 2 and 3, to make necessary correction in the notification to 2/11/2022 in respect of serial number 4, and to notify only the 3 posts of junior dental surgeon, which was created by the cabinet in its meeting held on 23/6/2020 to be recruited through the NPSC by the special recruitment drive. The remaining 2 posts which shall be filled up strictly in terms of the Nagaland Public Health Service Rule 2006. So 3-2. Then Lordship, may kindly come back to 1, the writ appeal. And the writ appeal was 5. Lordship, the first day, yes. 1. Lordship, I will kindly allow me to refer from paragraph 4 because it may have a bearing on the case. The cabinet of the government of Nagaland's meeting held on 23/6/2020 took up the agenda for recruitment of doctors such and such. The cabinet, upon deliberation of the matter at length and taking into account the unprecedented situation arising out of COVID-19 pandemic and the need to address the inadequacies of state health system, including shortage of manpower at requisite levels, approved creation of various posts in the Department of Health and Family Welfare. It is very pertinent at this stage to mention that as serial number 4, the cabinet decided creation of 3 posts as dental surgeons. In addition, the cabinet also issued direction to be followed when making recruitment in those posts which are enumerated in clause such and such. Clause P categorically mentions that the department should clearly indicate that this appointment should be temporary and regular recruitment shall be conducted through NPSC special recruitment drive. I'm reading 6. Pursuant to the advertisement was issued for recruitment at temporary basis. The department report filled up 5 posts of junior dental surgeons. The said advertisement, however, refers to 2 notifications that is such and such, which, however, is not part of the record. The said advertisement, Lordship, advertisement also stipulates terms and conditions for the post of junior surgeon, and one of such conditions is that engagement shall be for a period of 1 year and can be terminated anytime with 1 month's notice either by the employee or the employee. It was also mentioned that appointed on the basis of recruitment drive shall have no claim for regularization of the contingency service on any ground whatsoever. The applicant here truly participate pursuant to the said advertisement in the selection process and they were shortlisted. The appointment were appointed by order dated such and such for 12 months only or till regular appointment is made through the NPSC, which it is earlier. The service of the applicants were therefore again extended for another period of 1 year or till the matter is filled up to NBSC, which is further, which is early. The report further reveals that the cabinet of the government of Nagaland took another decision on 25/5/2022, whereby the relaxation of recruitment rules for special recruitment were discussed. It is very pertinent to mention to take note of that in clause 2 of the memorandum, it was mentioned that the department would carry out the recruitment for newly created posts. It was specifically mentioned that only 3 posts of dental surgeons were created. Clause 4 of the cabinet said meeting dated 25/5/2022 further detail out the manner in which special recruitment could be carried out. A perusal of Form 1 shows that the selection to be carried out in the special recruitment drive would be based on written examination in such and such. Also, I'm skipping it. We have read that one already. Paragraph 9. A notification was issued on 2/11/2022, where various posts were notified for recruitment through special recruitment drive. Amongst the posts, as number 4 were the post of junior dental surgeon, and vacancy was shown as 5. In clause 4 of the said notification, that the manner in which marks were to be awarded was stipulated, which was very material to the clause 4.1 of the memorandum of 2022. It is also very pertinent to mention that notification dated 2/11/2022 was issued on the basis of the cabinet memorandum of 25/5/2022, which was approved on 26/5/2022. The Lordship, and I am reading from paragraph 14, the operative paragraph. We have heard the Learned Council appearing on behalf of the parties and given our due consideration to the relevant submission. In the previous sequence of the instant judgment, we have already taken note of the cabinet memorandum of 2020 as well as the cabinet memorandum of 2022, where in it was categorically mentioned that the creation of number of posts for junior dental surgeons was only 3. However, it is certain that the notification dated 2/11/2022 have mentioned 5 posts of junior dental surgeon at serial number 2. To the said notification is based upon the cabinet memorandum of 2022 as well as the approval of 26/5/2022. We have taken note of the submissions. The Learned Council appearing on behalf of the Family Department, who submit that there was a mistake so committed in incorporating 5 posts for purpose of SRT, as such necessary correction was required to be carried out. Under such circumstances, only 3 posts were calculated for the purpose of SRT. The notification dated 2/11/2022, which was issued in pursuant to the cabinet memorandum to that, had mentioned more than 3 posts of junior dental surgeon as shown number 4 of the said notification. Under such circumstances, we have the opinion that the single judge was justified in passing the order dated 14/5/2024. Accordingly, we find no ground to interfere with the order dated such as just passed into PPC. So my respectful submission object is that the validity, whether the special recruitment to be conducted in terms of the cabinet decision of 2020 and 2022 was a subject matter before this honorable court, and the Senate and the Learned Single and Lordship may kindly appreciate the fact the prayer before the Learned Single Judge was to set aside the notification and to conduct advertise and conduct the rule for 5 posts in accordance with the service rule of 2006, prayer number 2. However, Lordship, the Learned Single Judge as well as the division bench has upheld the special recruitment drive for COVID appointees by relaxing the rules. And this is attempt is finality. So, with due respect, Lordship, this honorable court is bound by the judgment of this honorable of the single bench as well as the division bench. Lordship may kindly give a serious thought to this judgments. Secondly, Lordship, coming back to page 41, posts were created for a special recruitment drive. Now, this is not challenged by the petitioner. It is not a normal vacancy. From the creation, it is a vacancy created for special recruitment. And it is not a normal vacancy. Then Lordship may kindly come to page 43. The NPSCs, which this is a letter by the NPSC which my learned friend has really heavily relied upon. in inviting a reference to the above cited subject and health and family welfare notification dated 2nd November 2022, Lordship, which just before the 2nd November 2024, I am direct to state that the special recruitment proposed by the department is not in accordance with the recruitment rules of the commission. You are therefore requested to kindly accord clearance to proceed with the recruitment process. You are Lordship, kindly note the next slide. You are therefore required to kindly accord clearance to proceed with the recruitment process. It is not two things are mentioned here. First paragraph and second paragraph, two issues are mentioned. Lordship may kindly appreciate the fact that the cabinet decision of 2020 and 2022 had relaxed the service rule of 2006 only. Not the Lordship NBSC statutes. Because Lordship NBSC is a Lordship independent body and the cabinet may not have power to relax the statute of the NBSC. Only the health service rule of 2006 was relaxed. So the NBSC replied in paragraph 1 that since the relaxation proposal for a special recruitment trial it is not in accordance with the NBSC recruitment rules, you are therefore requested to currently accord clearance to proceed with the recruitment process. So green signal was given that you go ahead, but I'm not able to do it because my rules prohibit me. That is the meaning. Not so in that now in view of this letter of Lordship 10 November 2022, my learned friend has made a strong submission that the cabinet decision of 2020 and 2022 has become redundant. Lordship, in my respectful submission, it is not become redundant because it is not the case where NBSC has rejected in toto. NBSC said, I'm not able to do because my commission rules has not been statute has not been relaxed, but you can give clearance to proceed with the examination process as already decided by the cabinet. Then Lordship, the next page. Accordingly, Lordship may kindly see the next page. Pursuant to the NBSC letter, Lordship, the government department put up a proposal for special recruitment drive in respect of medical officers in reference to government letter dated such and such cabinet approval of 2022. The chief list of medical officers under special recruitment drive is submitted for necessary action. Then Lordship, the annexures serial number 3, annexure A, 88 doctors serving as engagement basis appointed during the event. COVID. My lord, my name appears at serial number 3 at page 51. My lord, page 51 to page 57 are the names of respondent number 19 to 101. In other words,
Page 51. Serial number 1 to
Lordship,
in this
yes,
chart.
Lordship, annexure A.
In this annexure A2,
yes,
page
all,
51.
because 83
All.
numbers.
Oh, 83. Okay,
83
okay.
in numbers.
So your respondents number
Number, Lordship, 19 to 23, 25 to
19
101, but 24 is also included.
24 is also there. Yes.
Yeah, my younger friend also included. So
So all the respondents.
yes,
19.
respondents number 19 to 101. And my friend will highlight about the contract employees, their names also included. But I'm not referring to them for the moment.
But those are not appointed during COVID.
Yes. Then Lordship,
This is annexure 2.
then Lordship, mechanical the page 58. This is UU number 478 dated 15/7/2024 issued by the UPSC Lordship. The Commission has examined the file relating to conduct of special recruitment drive for COVID-19 appointees in respect of Health and Family Welfare Department and conveys the decision of the Commission that since the department has withdrawn the requisition post in question on valid reason. Lordship, kindly appreciate this fact. On valid reason, while letter number dated 9 July 2024, NBSC has no comments issues on the proposed special recruitment drive for COVID-19 appointees to be conducted by the Health and Family Department, as the whole exercise is within the prerogative of the department government. Lordship, my learned friend has tried to make a distinction that it is only a departmental exam and it is no more special recruitment drive. It is not so. Lordship, you can see from letter page 50, the last annexure 18 and 19, and the protocol clearance given by the NPSC on 15/7/2024, it is special recruitment drive to be done departmentally. And Lordship, the clearance by the NPSC on 15/7/2024 to conduct a special recruitment drive departmentally is not challenged. This is not challenged in the present writ petition. My learned friend has taken a specific submission that the cabinet decisions of 2020 and 2024 has become redundant, but he is silent on this. Then, Lordship, thereafter, pursuant to that, at page 59, the proposal was submitted by the department for a special recruitment drive on 2nd August 2024. Then, Lordship, the cabinet memorandum was prepared at page 61. My lord, to save time, kindly allow me to refer to paragraph 3.
Yes.
The issue of special recruitment drive to NBSC was originally approved was referred to NBSC. In the course of discussion, the commission expressed the view that it would not be appropriate for it to conduct an exam of such nature. However, the commission has conveyed that the process of regularization of the COVID-19 appointees as mandated by the state government in the High Court. My lord, when he's talking about cabinet nobody's High Court is about the writ appeal for the NPA, which the lordship is just referred for the splinter searching. Within the mandate of the department, a copy of the clearance of NPSC is enclosed to facilitate this clearance. The department has also written all requisition made to NPSC and SSC for regularization of posts under special recruitment drive. My lord, the word is under special recruitment drive. Then my lord my learned friend has referred to all that. So my lord, and Lordship Mikali is page 62 at 45, 5. Permission may be granted to recruit the 4 categories of posts that are yet to have service rules, since it would be unfair to leave them out. Subsequently, their service condition may be subject to the provision of service rule as and when framed. I'm referring to the others with my lord, the
Meaning
research
the research
Research.
centers.
Then Lordship at 63.
What about dental? They also don't have service rules. No,
The-
they are governed by this 2006,
2006 covers dental and Lordship
the
medical
medical officer.
Rule 5. Then Lordship, minutes of the cabinet. This is which is challenge. Lordship, kindly allow me to read it again. 7 August 2024, page 63. Minutes of the cabinet on 6 August 2024. The undersigned is directed to forward here with an extract of the minutes of the cabinet held on 6 August 2024 for kind information and necessary action. Agenda 3, regularization of service of cabinet. The COVID-19 appointees to departmental screening committee in relaxation of the earlier approved procedures. It is only talking about the relaxation of the procedures, Lordship, because NBSC has declined and give clearance to have a special recruitment drive departmentally. Rules has been relaxed already, Lordship. So it is not necessary to relax the rules over and over again. 2020 cabinet decision of 2020 and 2022 has relaxed the service rules and the procedures. But since NPSC has raised its inability, Lordship, and give its approval, now the procedures is relaxed. So my lord, thereafter at 64, Lordship, if ministry approval granted on 30th 20th August 2024. Administrative approval to conduct written in viva voice of one-time dispensation of special recruitment drive of the special categories. With reference to the letter dated such and such and the subject cited above, as approved by the Cabinet on 7 August 2024, I am directed to convey the approval to the government to conduct written exams in viva voice of one-time dispensation of special recruitment drive of the special categories 250 posts of engaged persons. So this is now Lordship. Lordship, may kindly see the prayer at page 43 to the writ petition. This is challenge. Definite decision and letter dated 28,
28, 24.
2024 are challenge. And then, my lord, here, Lordship, kindly allow me to seek a clarification to you. No. Lordship, may kindly come to, it is 146. Lordship, it is not challenge. Lordship, may kindly see, Lordship, may kindly see the prayer in new letter dated 28, 2024, annexure Q. Lordship, is found at page 43 to the writ petition. In my noting, it is shown not challenge. Writ petition, page 43.
46, annexure Q. Annexure Q is different.
Yes, Lordship, annexure, Lordship, may and kindly allow me, come to page 145 and 146 to the writ petition.
So this is.
I'll clarify, Lordship.
This is the calling letter.
Yes, only the calling letter, annexure Q, and it is also 28, 2024, Lordship, you can see the same date. Both are 20 August 2024.
This 28, 24, the administrative approval.
The administrative approval and the calling letter were issued on the same date, Lordship.
Administrative approval is annexure P.
Yes. Only annexure U and Q are challenged. So, my lord, the administrative approval is the form, is the basic order pursuant to the cabinet. In fact, in red, I have written in my paper, it is not challenged, that's why I am checking it again. Dates are same,
Yes,
but
dates are same.
Lordship. So, my lord, the administrative approval to conduct the exam on 26 August 2024 for written, viva voice on 27, 28 pursuant to the cabinet. It is not challenged, only the calling letter was challenged. So, in view of this facts and circumstances, yes. So, my lord, in my affidavit.
So, this 280 posts which is mentioned here, does it also include the
Nurses.
posts? No. Does it also include the posts of those contract employees
Yes.
who were appointed
Yes.
before COVID?
Yes, they're all included. They're all included. So, my lord, I have made a specific plea in my affidavit in opposition that without challenging, in the absence of challenging the basic orders, the consequential orders cannot be challenged. And to that reply, my letter friend who was making a submission in the court, in the bar, as well as in his affidavit, reply affidavit, that all those orders has become redundant. It is not necessary to challenge. My lord, whether those cabinet decision of 2020, 2022, and the administrative approval letter dated 20th August 2020, then relaxation given, permission given by the NPSC on 15/7/2024, creation of post for SRT, whether those are redundant or not, have that Lordship may kindly examine in my respectful submission. It is not redundant. These are the basic orders. on the basis of which post has been created and examination are to be conducted. So to take a simple, in spite of notice, in spite of notice, in my affidavit in opposition, his categorical stand is it is redundant. Now, not it is redundant, so it is not necessary to challenge. In other words, he's conceding. Lordship may very appreciate this fact. When he say it is redundant, it is not necessary to challenge. The writ petitioners are conceding all these orders. In other words, Lordship, however, my respectful submission, this is the basis. The decision of the cabinet on 2024 was only to relax the procedure of the SRT. That is, instead of SRT to be conducted by the NPSC, now the SRT to be conducted departmentally. Only that much of 2024, which is challenge. However, Lordship, the decision for creation of the post for SRT, the decision for relaxation of the rules and procedure for Lordship, for appointment, for recruitment, regularization, and continuation of age has not been challenged. And Lordship, you can appreciate the fact that many of them are now going to be nearly 50 years. So, because our age was
45.
Was-
It was 45.
Yes, was 45. So many of us who were at the age of 45 or on the verge of 45 appeared for exams. So we are nearly 50 years now. And where will we go? In fact, Lordship, the date of births of the respondents, if your Lordship may kindly say page 51 onwards in my affidavit in opposition.
1 minute. Yes,
That's
page.
page 51. The date of births, some of them, Lordship, 79, Lordship, at page 51 on the right-hand column. Serial number 1 is 82, then Lordship, you kindly say up to 79 and 89. Also, Lordship, if you Lordship, you kindly sum up at page 52, serial number 26 is now was born in the year 1977. So, my lord,
Mm.
where will we go? In fact, most of them are 37 plus.
Mm.
Almost all the 37 plus. So, my lord, if there is no SRT, then we'll be out for it. And one of the conditions was that age will be relaxed up to 45 years, and we were given commitment. And in fact, Lordship has already in the cabinet memorandum, since my learned friend has read, I'm not repeating it. It was clearly mentioned in the cabinet memorandum for 2024 that assurance was given to the petitioners when we were respondents when we were in service that your case would be considered for regularization to special recruitment track. That is mentioned in the cabinet memo of 2024. Just to save time, I'm not repeating that. So, my lord, in that situation,
That is mentioned in cabinet memo of
yeah,
2024.
Lordship, if
Okay, no, it's okay. Yeah. I just want to. Mm. Yes.
So, Lordship, I'll refer to some of the judgments, the remaining judgments. Now, Lordship, the serial number 2 is on maintainability, Lordship. That is the 2013 for SCC 465. Lordship, I have mentioned the paragraph 9 to 11. It is person aggrieved.
Hmm.
It is a simple proposition that a stranger cannot be permitted to meddle in any proceedings unless he satisfies the authority court that he falls within the category of aggrieved persons. Only a person who has suffered or suffers from legal injury can challenge the action in the court of law. A writ petition under 226 of the Constitution is maintainable either for the purpose of state enforcing a statutory legal right or when there is a complaint by the appellant and there has been an injury of statutory duty on the part of the authorities. I'm skipping that. 10th, a legal right means an entitlement arising out of legal rules. Thus, it will be defined as an advantage or benefit conferred upon a person by the rule of law. The expression person aggrieved does not include a person who suffers from psychological or imaginary injury. A person aggrieved, therefore, must be necessarily one whose right or interest has been adversely affected or jeopardized. 11. A similar view was taken by this court observing that a person claiming relief is not eligible. That if a person claiming relief is not eligible as per requirement, then he cannot be said to be a person aggrieved regarding the election or selection of other persons. So that is with regard to maintainability doctrine, because my respectful submission is when these rules are issued. Only 3% had the requisite qualification as medical doctors. They refused not to apply, decided not to apply. The rest were all students. And Lordship, subject to repetition, Lordship may appreciate the creation of the post. It is not a normal vacancies creation. It is a post created under special circumstances.
Yes, created during COVID.
Yes. So then Lordship may kindly come to the next. It is mark 3.
Yes. 2009, one is.
Yes. 2009. Lordship, I'll be relying heavily on this. Lordship, kindly allow me to read from paragraph 4 so that you, Lordship, may kindly get a picture of the facts of this case. May I read from paragraph 4? The appellant filed 2 separate writ petitions before the High Court of Gauhati challenging the cabinet memorandum circulated by the Commissioner Secretary of Assam Social Welfare Department under Rule 17 of the Assam Rules of Executive Business relating to regularization of 18 CDBOs who are appointed under regulation such and such. And praying for direction to the state to appoint the appellant's vacancies created probation officers. The appellant also challenged the policy decision taken by the state to regularize the service of respondents who were initially appointed temporarily under such and such could not success in the selection process conducted by the Assam Public Service Commission. The appellants contended before the High Court had given benefit of regularization to service to the previous respondent to the post of CDBOs was contrary to the recruitment rules, and the action of the state government would amount to a backdoor entry to the unsuccessful candidates into the state services. The stand of the respondent before the High Court, state before the High Court was that 27 equities vacant post meant for direct recruitment quota was filled up by the state government on merit out of select list prepared by FPSC dated 17/7/2020. The select list having thus exhausted the appellants whose names figured below 27 selected candidates in the select list, therefore could not claim to be appointed in excess of the advertised vacancies of CDPOs, and if any further vacancies which arose after publication of the advertisement was to be filled out after left out candidates of the select list, the said appointment would amount to depriving other persons who in the meantime would have become eligible for selection to the appointment. It was also submitted as soon as the post advertised was filled up or the validity of the select list expired, whichever even was earlier in point of time. The candidates whose names appeared in the select list could not therefore claim appointment to the select list. Got exhausted. It was stated that appellants have later challenged the policy decision taken by the government on the basis of the cabinet decision, nor the notification issued pursuant by the state government regularizing the services of 18 CDBOs. It is also stated that the decision to regularize CDBOs who were initially appointed under regulations was taken by the state in view of the fact that they had already rendered more than 4 years of service satisfactorily, and their continuation in service was necessary to implement the time-bound schemes of the government of India, for which CDBOs projects were created in the state of Assam. It was categorically stated that 18 CDBOs were regularized by the state government to the post meant for promotees. 11, paragraph 11. The letter single judge of the High Court dismissed the writ petition of the appellants in India, holding that no post beyond 27 advertised could be filtered out from the select list, and the appellants have challenged only the cabinet memorandum without challenging the cabinet decision, followed by the notification dated 16/11/2020 issued by the state government, heard by the service of the private respondents come to be raised. That being agreed, the appellants filed the aforesaid 2 writ appeals, which has been dismissed by the division bench. Now, Lordship, I'm reading from paragraph 15 and 16. It is stated that cabinet memorandum was circulated under Rule 17 of the Assam Rules of Executive Business after obtaining the approval of the Personal Department of the Assam for regularization of service of the private respondents in the exceptional circumstances of the matter against 28 available vacancies made by promotees by invoking clause 11 of the service order 1994. On the basis of the cabinet memorandum, a cabinet decision was taken on 13/10/2000 granting approval of regularization of services of the respondents. The respondents state also submit that applicants have not challenged the one-time policy decision by the cabinet, nor has a notification dated 16/11/2000 issued pursuant to the cabinet decision regularizing the services of private respondents being challenged by the applicant before a single judge or a reviewing bench of the High Court. The High Court has rightly dismissed the writ petition and appeals of the appellants. Inter alia, on the ground that appellants have no enforceable right to get appointments to the post of CDBOs against promotional quota merely because their names had figured in the select list prepared by the APSC against the direct quota. The Lordship, from page 20, paragraph 20. Paragraph 20 to 23. The the state government has regularized the services of the private respondents against 18 vacancies in the cadre of CTVO, which were meant to be filled up by way of promotion from departmental candidates. As such, the appellants who have applied against direct quota have no legitimate right to be selected and appointed against the promotees quota. The private respondent also submitted that he has been regularized on the basis of the cabinet decision and the notification dated in reference to the clause 11 of the service order. He had submitted there was an urgent need on the part of the department to fill up all the vacant posts for the purpose of proper and effective implementation of time-bound projects of the state. It is stated that in view of the long service rendered by the private respondents and having due regard to their past satisfactory performance and also the vacant service record, they have been regularized against those promotional vacancies purely in public interest. It is submitted as subsequent by the notification dated such and such. APSC has also conveyed its approval to regularization of respondent services. They have also stated that procedure for regularization of the respondent services was a one-time measure adopted by the state government in the special circumstances, and the care regularization has not in any manner caused any prejudice to the interests of the applicants. The respondent also stated that the applicants has not challenged the cabinet decision and subsequent notification issued by the state government in the writ petition before them, nor have they challenged the same before the petition bench of the High Court in that view of the matter to private respondents submit that appellants have no locus standi to file the writ petition under 226. Lordship, may kindly come to page for paragraph 45. The decision of the cabinet. The decision of the cabinet in the notification issued by the state government pursuant thereto in our views are both in consonance of the conformity with clause 11 of service order to save the service of the private respondents from being thrown out of the job, thrown out of the job, which otherwise would cause extreme hardship and injury to them and to the members of their families. In the facts and circumstances of the present case, we find that the High Court has rightly held the appellant to not have any affordable rights of being appointed to the post of CTU against the quota meant for promotees, and more particularly against the decision of the state government regularizing the service of the private respondents. The cabinet decision was taken as a one-time measure, having regard to the special circumstances of the case, the satisfactory performance rendered by the private respondents in their last service report, which was found to be unblemished by the government, as well as in the exigencies of the scheme of central government, which were to be operationalized in a time-bound manner and also keeping public interest in mind. In this circumstances, the High Court is right in holding that the appellants have no locus standi to challenge the regularization of the private students against the vacancies made for promotion of quotas. The appellants who appeared in the interview held the FPSC as private candidates would not have any grievance against the regularization against 40% promotional posts. Last paragraph 48. In the backdrop of the above stated facts and the relevant provisions of the rules, we do not find any error or infirmity in the impugned judgment in order passed by the High Court, which would warrant any interference by this court in this appeal. None of the contention raised by the appellants merits acceptance. The law laid down by the constitutional bench of this court in Umadi in the present facts and circumstances would be of no help in assistance to the appellants. The decision of the Gauhati High Court in the cases cited at the bar by the Nursing Council for the appellants would turn on the facts and circumstances of the case, and ratio laid down therein cannot be made binding on the regular facts of the present case. So, Lordship, none challenging the policy decision and maintainability. On these two issues, my lord, in my respectful submission, this judgment will squarely govern my position, my case, the present case. Then the next judgment on policy decision, Lordship, the
Serial 4.
4. Lordship, I am reading paragraph 15 to 17.
Paragraph 15.
15, 16, since to 17, 15, 16, 17.
Yes.
It is right that courts would be slow in interfering in the policy matters unless the policy is found to be palpably discriminatory and arbitrary. This court would not interfere with the policy decision when a state is in a position to point out that there is intelligible differential in application of policy, and such intelligible differential has a nexus with the object sought to be achieved. Then 16, to ascertain unreasonableness and arbitrariness in the context of Article 14 of the Constitution, it is not necessary to enter upon any exercise for finding out the wisdom in the policy decision of the state government. It is a matter of whether a better or more comprehensive policy decision could have been taken. It is equally immaterial if it will be demonstrated that the policy decision is unwise and is likely to defeat the purpose for which decision has been taken. Unless the policy decision is demonstrably capricious or arbitrary and not informed by any reason whatsoever, or it suffers from vice of discrimination or infringes any statute or provisions of the Constitution, the policy decision cannot be struck down. It should be borne in mind that except to the limited purpose of testing public policy in the context of illegality and unconstitutionally, courts should avoid embarking on uncharted ocean of public policy. In treat such and such, as a matter of fact, the court would be slow in interfering with matters of government policy, except where it shows that the decision is unfair, malefic, or contrary to any statutory directions. Then, Lordship, next page 28. Basic order not challenged. I'm referring to only one paragraph. Go to paragraph 28.
This is on basic order not.
Yes, basic order not challenged. My lord, it is all I have in my note, it is all mentioned in the first page.
What's it? Okay. Para?
28.
Yes.
In the instant case, promotion has been made by two different TPCs. Both TPCs have made promotions under different rules on different criterion, and the promotions have been made with retrospective effect with different dates notionally. In the writ petition before the High Court, the promotion of the appellants had not been under challenge. The seniority which is consequential to the promotion could not be challenged without challenging the person. Challenge the promotion. Challenging the consequential order without challenging the basic order is not permissible. I'm only challenging. Then finally, Lordship, the last judgment on Lordship on a void order has to be challenged. Paragraph 16 to 19, Lordship, the sixth one. Married Lordship, 16 to 19. It is a settled proposition that even if an order is void, it requires to be declared by the competent court, competent forum, and it is not permissible for any person to ignore the same merely because in his opinion the order is void. In such and such, this court held that whether an order is valid or void cannot be determined by the parties. For this sitting aside such an order, even if void, the party has to approach the appropriate forum. In such and such, this court held that the party agreed by the invalidity of an order has to approach the court for relief of declaration that the order against him is inoperative and therefore not binding upon him. While deciding the said case, this court placed reliance upon the observe such and such an order, even if not made in good faith, is still an act capable of legal consequences. It bears no ground of invalidity on its forehead, unless the necessary proceedings are taken in law to establish the cause of invalidity and the same and get it quashed or otherwise offset. It will remain as effective for its ostensible purpose as the most implicable of orders. In such and such, this court took a similar view, observing that once an order is declared unasked by the court, only then judgment of nullity would operate for and against everyone concerned. Such a declaration is permissible if the court comes to the conclusion that the order of the order lacks inherent jurisdiction, competence, in terms, or it comes to the conclusion that the order suffers from patent embedding invalidity. Thus, from the above, it emerges that even if the order notification is void or legal, the party agreed by the same did not decide that the said order notification is not binding upon it. It has to approach the court for seeking such declaration. The order may be hypothetically a nullity, and even if its invalidity is challenged before the court in a given circumstance, the court may refuse to quash the same on various grounds, including the stunting of petitioner, or on the ground of delay, or on the doctrine of waiver, or any other legal reason. The order may be void for one purpose, or for one person. It may not be so for another purpose or another person. So my respectful submission to make a claim that the 2020 cabinet decision and 2022 cabinet decisions has become redundant, although or not challenging the creation of posts or cabinet or the MPSC letter of 2022, two letters. That it is not redundant, it is not applicable to me, not it does not hold water. In my respectful submission, that holds the field, that is the basis. And without challenging that, whether the petitioner have any locus right to challenge only the relaxation of the procedure, because the issue is lordship, relaxation of the rules. Relaxation of the rules has not been challenged. That has been upheld by the single bench and division bench of this honorable court in that holds the field. So in that particular facts and circumstances of the case, my respectful submission is that this petition is not maintainable and it should be rejected summarily. Doctor also may kindly appreciate the fact that written examination was supposed to be held on 26th of August 2024.
Yes.
Today is 21st July of 2025. So my respectful submission, Lordship, and Lordship may kindly appreciate the fact that for 34th, written examination has been conducted already. So my respectful submission, because Lordship,
There is an interim order.
there is an interim order to
Stay
the process.
stay the process.
So examination could not be held. So my respectful submission in all the facts and circumstances of the case. This honorable court may kindly direct the respondent authorities to conduct the SRT in a time-bound manner, Lordship, maybe preferably 2 weeks from the date of judgment. Because otherwise the question of seniority also will come by God's grace if we succeed. And the question of reasonableness will come into. So my lord, that is my humble submission. Much appreciated.
Yes. Now,
I'm not going by the precedents. Actually, up to the petitioner, government, thereafter respondent and secretaries. However,
yes.
my learned friend, Mr. Takamasa, he has filed a writ petition. So he is in one case for the petitioner and in the other
In
case
other
he is the
petition.
respondents, 19U101.
Mm.
That is why he has taken the precedence and let the government respond to it, and thereafter only the private will come. Private respondents lordships.
Yes.
So my learned friend, additional advocate general.
Yes. Who's appearing? Oh, but you're also appearing, huh?
Yes, my lord.
Malaria
Are you adopting the submissions?
We are-
Yes,
similarly situated.
yes,
So I'll be adopting the submission, extensive submission made by my domiciliary
yes.
officer.
You are for
File
respondent
number 24.
24.
However, additionally to supplement his submission, I would just submit 2
Hmm.
proposition
Hmm.
with regard to the case of the petitioner and with regard to my case in particular.
Hmm. Yes,
Malady, you have extensively heard with regard to the documents, so I will not refer to it. But then the fact remains that the first point proposition I want to make is that in the instant case, the petitioner is only aggrieved by the decision and not the decision making process. Why? Because they have not challenged the basic order and the subsequent orders. They are only aggrieved by they have only challenged annexure O and annexure Q, which says that they are only aggrieved by the decision. So it is my specific submission that in the absence of such specific challenge to the decision-making process, the judicial review is limited. Judicial review in decision-making process per se is limited. So to support my contention, argument, I want to place reliance on one judgment, 2006, 8 SCC, page 200. Just one paragraph. Paragraph number 18. If I may read my lady. Paragraph number 18, page 209.
Yes.
Having regard to it all, it is manifest that the power of judicial review may not be exercised unless the administrative decision is illogical or suffers from procedural impropriety, or it shocks the conscience of the court in the sense that it is in defiance of logic or moral standards. But no standardized formula universally applicable to all cases can be involved. Each case has to be considered on its own facts, depending upon the authority that exercises the power, the source, the nature of scope of power, and the indelible effects it generates in the operation of law or affects the individual or society. Though judicial restraint, albeit self-recognized, is the order of the day, yet an administrative decision or action which is based on wholly irrelevant considerations of material or excludes from consideration the relevant material, or it is so absurd that no reasonable person can have arrived at it on the given material, may be struck down. In other words, when a court is satisfied that there is an abuse of or misuse of power and its jurisdiction is invoked, it is incumbent on the court to interfere. However, it is nevertheless tried that the scope of judicial review is limited to the deficiency in the decision-making process and not the decision per se, not the decision. So here, the Supreme Court has clearly stated that the judicial review is limited, very limited to the extent that it cannot be, the court cannot interfere unless it, first of all, affects the conscience, shocks the conscience of the court, and second of all, it is limited to interfere to the decision-making process. So here in this case, the petitioner, by excluding to challenge the basic order and the administrative approval and subsequent orders, they are merely aggrieved, or they are merely aggrieved by the decision. So now to again further factually support this, base my argument. For instance, on the question of locus standi also, whether the petitioner were they have the locus to challenge the initial appointment. First of all, apart from petition number 1, 11, and 55, none of them were eligible at that point of time. And even petitioner number 1, 11, and 55, they waived off their rights. They did not participate in the advertisement, in the process, in the decision-making process. So now, since they waived off their right and none of the other petitioners did not have the required qualification, they did not have the locus, they do not have the locus to challenge the initial decision of the state. Now, whether it will be right to say that they have the locus to again challenge the subsequent, we cannot isolate the initial appointment. It is my humble submission that we cannot isolate the initial appointment and the subsequent decision to regularize or go for a recruitment process to for a one-time dispensation to regularize them. So that is my first submission.
Then
Second, and which is my last submission, my elder brother, the counsel for a petitioner, has extensively mentioned about the due process. Now, we have my learned counsel, my senior counsel has said that, has extensively argued on the fact that the recruitment rules were relaxed. Recruitment rules were relaxed, and the SRT was a consequence of that relaxation.
Mm.
Now, when we talk about due process, there is a reason why the constitution makers did not insert the word due process in the constitution, because the concept of due process is elastic and it has to be based on the facts and circumstances and the time, extraordinary time that it has to apply. So my submission is that the
Yes,
appointment-
extraordinary circumstances
Yes.
already mentioned.
Yes, extra. So it was an emergency adaptation. And the second was, again, the relaxation was uniformly applied to both the respondents and the petitioners.
Mm, mm.
Third, the state demonstrated, in my opinion, the state has demonstrated an act of fairness with regard to the appointment and with regard to the SRT, to go ahead with the SRT. Now here, in the previous argument, the doctrine of legitimate expectation was also mentioned, but I want to supplement that with another doctrine, the doctrine of necessity, which is an exception to the general rule. So at that point of time, it was a necessity and it was an extraordinary, like my lord has said, extraordinary circumstances. So
Yes.
with regard to that, I want to supplement the submission with another additional, the doctrine of necessity, which is an exception to the general rule. Now, the last submission is that the state did not have any mala fide intention, and for which, even in the petition as well as during the argument, the petitioner did not have raised any issues on the mala fide intention of the state to go ahead with the SRT and also to appoint them during the COVID-19 pandemic by relaxing the rules. So in essence, the concept of due process was duly followed in my humble opinion. So with that in mind, I humbly request this honorable court not to interfere with the imperial letter, which is the order, which is imperial letter dated 28/2024. That is my
Okay.
submission. And the last authority that I want to place with regard to my submission is 2003 SEC online, all 359. This is short. This one. Paragraph number 5. May I read? It is settled proposition of law that unless the order and the challenge is filed and placed on record, the court has no power to crush the same. In Surrender Singh versus central government, the Honorable Supreme Court has held that the High Court cannot pass an order in such a case in absence of the imperial order being on record. This might not be relevant, but this, I want to refer to this. In absence of order and the challenge, the High Court could not crush the same. Normally, whenever an order of the government of some authority is impugned before the High Court under Article 226 of the Constitution, copy of the order must be produced before it. In absence of the imperial order, it would not be possible to assign the reason which have compelled the authority to pass the order. It is therefore improper to question order which is not produced before the High Court in a proceeding under Article 226 of the Constitution. In essence, the relevant orders or decision that they ought to have challenged was not a part of their pleadings. This is my humble submission.
No, it is a part of the pleadings, but they have not challenged. Okay.
Vice President.
Yes.
My name is, the private respondent number 101. 101, they serve as well as appointed during the COVID time. They serve and appointed during the COVID time So these are a special case and they need special attention and consideration by this court. Mainly during the time of the high surge of pandemic, where everybody's beats and fear for their life. There is a shortage of medical doctors as well as medical health workers in the state of Nagaland to tackle the pandemic, for which the department we have created 120 posts of medical doctors. Through notification, there are different notifications, which my letter has already.
Yes,
referred to
yes.
in order to in order not to waste it, I would not have 120 posts of medical doctors was created. And at that point of the creation, there were 48 regular vacancies. So those 48 regular vacancies were added to the 120 newly created posts, and they were advertised. So it come out to 168 posts.
So 120 were created and then how many were there?
48
48.
vacancies were there. Regular vacancies were there at that point of time. So these regular vacancies were added to the 120 newly created posts, and it come out to 168 posts which were advertised.
168. Yes. Okay.
Yes. If we look at to the cabinet memorandum as well as the cabinet approval, it is specifically mentioned about this special. It's not about the regular recruitment. It always talked about the special recruitment, special recruitment through MPSC, special recruitment. So here at that point of time, when the 168 posts were advertised, the petitioner, though the petitioner 111 and 55 were qualified at that point of time, 3 of them they did not participate in the selection process, and the rest of the petitioners are undergoing MBBS courses already. So this classification of the person, the special recruitment drive is only meant for those in medical service medical doctors
Appointed during COVID.
who had served or appointed during the COVID pandemic. So the petitioner, they never served during the pandemic. So they form a different class. So the classification for this group of people, and in order to give them a regularization to this group of people, does not amount to discrimination. Only when the petitioner, they are equally circumstanced with the petitioner, only then only they can file a case. They are not the aggrieved person. And regarding with the service rule, my lady has already seen that the office memorandum of 2020 as well as the 2022, the service rule has already been relaxed.
Next.
So if my lady will come to page 126 of the petition. One 26. I will read this is the notification dated 2/11/22. Read the paragraph 2.
Yes.
The special recruitment drive shall be conducted by the Nagaland Public Service Commission and the Nagaland Staff Selection Board. So this is the policy of the government when we created the post. Through an advertisement, person were to be recruited and engaged on a temporary basis only. And thereafter, a regular recruitment is to be conducted through a special recruitment drive. That is the intention of the government. through a special recruitment drive through NPSC. So when we forwarded the matter for a special recruitment to be conducted by the NPSC has declined, saying that it does not come within the commission's rule to conduct a special recruitment. Because in the special recruitment, we have formulated as to how the marks are to be determined. Yes. So for which the NPSC, they have declined, that is at page 29 of my
Yes,
Evidently.
we have seen.
and thereafter, page 30 also, they have said that it does not come within its purview, so it is the prerogative of the government. That is at page 29 and 30. So, my lady, this group of people, the 168 posts when we advertised, some after appointment, they resigned from the post. Some they did not apply for extension. Some they did not accept the appointment order because of the fear of their life. That is the situation, the extraordinary situation that we had faced during that point of time. And right now there are COVID appointee 83 active in service. Active in service, and the 15 contractual appointees who served during the COVID
83 appointed
yes,
during
83 active in service, public appointee. And 15 contractual in service. Yeah, who served during the COVID period?
Acha, these are the ones who were appointed earlier.
Yes, 15 contractual appointee. They served during the COVID period. They risked their life. So it comes to 98 medical doctors for which we have shortlisted for recruitment through special recruitment drive.
So 83 plus 15.
So, my lady, you have seen that many people that have resigned, some they did not apply for extension, some they did not accept the appointment orders. And this group of people that served during the COVID period, risking their life and tackling the COVID situation, for which the government we have brought out a policy, a commitment to them that they would be regularized through a special recruitment drive. Our initial intention was to be conducted through the NPSC, but the NPSC declined, for which now we have put up the cabinet proposal that is at page 142 of the writ petition, cabinet memo, 1/8/2024. I'm going to read the my learned petitioner counsel as well as my senior colleague has already read, so I want to.
We have seen, yes.
Yes, 142, this is the cabinet memorandum for which the proposal was put up and by.
To have a
144.
departmental
Yes,
screening.
the cabinet has approved. It says about the relaxation of the earlier approved procedure. Earlier, our procedure was to be conducted through NPSC. So this is only the approved procedure. Now the procedure would be through the departmental screening committee.
But you were saying just now that there are now, how many of them? 90 altogether? 98.
Yes,
Okay.
98 medical doctors.
Okay,
names are
98 medical
yes.
doctors.
Shortlisted for special recruitment drive.
And 280 is including all those others, research
Yes,
scientists and dental surgeons
yes,
and
but
all that.
not- we are concerned with the medical doctors in this case. Yes,
No, but the other cases,
the
It
other
includes-
cases, yes,
mm.
medical doctors and
research
research
scientists and
scientists,
dental,
yes,
they also come within this 280 posts.
yes, 280 posts, they come in that. Yes.
And they were also appointed during COVID.
Yes, they were appointed to during the COVID. But in the case of This one. Lordship, in the case, minority in the case of 31, that consists that is 31, this is Abulu and Yepto. This also pertains to medical doctors where they resign and are no more in service. They are undergoing PG course.
Acha, acha.
Yes.
WBC 187.
2024. The petitioners are all medical doctors who were appointed during the COVID period, but they resigned.
Okay.
Some they did not apply for extension, and
Mm.
now they are undergoing medical PG course.
Mm. But the condition was there that they should not go for further
Yes,
studies.
for further studies. But they went ahead without informing the respondents.
Mm.
authority.
Okay.
So my lordship, taking into consideration the selfless service that they served during the COVID period,
Mm.
the government we have committed to regularize this group of people.
Mm.
Because this group of people, they are different from other normal group of people. So a special consideration need to be taken into.
Mm.
And regarding the petitioner, they are not an aggrieved person because they are not in this group of person. They did not serve in the during the COVID period.
Mm.
At that point of time, the opportunity was open to them.
Mm.
3 of them
They did not
refused
apply.
yes, and the others 1, 2, they are still students. So they are not a aggrieved person to challenge the policy of the government.
Mm.
But with regard to the person aggrieved, my learned senior counsel has already pointed out what I will in 2013 for ACC 465. I'm referring to paragraph 9, 10, 11, 12, 16, and 17. Should I read or
Wait, it's
yeah.
okay.
Yes.
9, 10, 11, 12,
16 and 17?
16 and
Yes, with regard to the.
this is on
person.
a grief person.
Yes, the petitioner are not a aggrieved person, so they cannot challenge the policy, the action of the government.
2013 for ACC 465. no?
Yes, 465. Then with regard to the classification test, lordship, my lady, 2022 ACC online, SC 420.
2002.
State of Uttarakhand verse severe Budamati and others. Para
2022.
SCC online.
56. Yes. I've got the, anyway, you just let me know the para.
Classification test and policy decision of the state. In my
Classification. The paras may not tally.
yes, but
Let's see.
mine is paragraph
14. Oh, yes, it's there. 14.
The heading is
Classification tests and policy decisions of the
yes,
state.
Yes,
Para 14.
yes, 14. Any differential treatment on its own cannot be termed as an anathema to Article 14 of the Constitution. When there is a reasonable basis for a classification adopted by taking note of the exigencies and diverse situations, the court is not expected to insist on absolute equality by taking a rigid and pedantic view as against a pragmatic one. 15. Such a discrimination would not be termed as arbitrary, as the object of the classification is meant for providing benefits to an identified group of persons who form a class of their own. When the differentiation is clearly distinguishable with adequate demarcation duly identified, the object of Article 14 gets satisfied. Social revenue and economic consideration are certainly permissible parameters in classifying a particular group. Thus, a valid classification is nothing but a valid discrimination. That being the position, there can never be an injury to the concept of equality enshrined under the Constitution, not being an inflexible doctrine. 16. A large latitude in dealing with a challenge to the classification is mandated on the part of the court when introduced either by the legislature or the executive, as the case may be. There is no way courts would act like appellate authority, especially when a classification is introduced by way of a policy decision, clearly identifying the group of beneficiaries by analyzing the relevant materials. 17. The question as to whether a classification is reasonable or not is to be answered on the touchstone of a reasonable common man's approach, keeping in mind the avowed object behind it. If the right to equality is to be termed as a genus, a right to non-discrimination becomes as SPC. When two identified groups are not equal, certainly they cannot be treated as a homogeneous group. A reasonable classification thus certainly would not ensure the equality enshrined under Article 14 when there exists an intelligible differential between two groups having a rational relation to the object. Therefore, an interference would only be called for on the court being convinced that the classification causes inequality among similarly placed persons. The role of the court being restrictive, generally the task is being left to the concerned authorities. When a classification is made on the recommendation made by a body of experts constituted for the purpose, court will have to be more wary of entering into the said arena, as its interference would amount to substituting its view a process which is best avoided. 18. As long as the classification does not smack of inherent arbitrariness and conform to justice and fair play, there may not be any reason to interfere with it. It is the wisdom of the other means which is required to be respected, except when a classification is bordering an arbitrariness, artificial difference, and itself being discriminatory. A decision made sense the aforesaid situation cannot be tested with either a suspicion or a microscopic eye. Good faith and intention are to be presumed unless the contrary exists. One has to keep in mind that the role of the court is on the illegality involved as against the governance. And with regard to the policy bylaw 19, for the aforesaid principle of law, we would like to quote the elucidation of this court in the following judgments. Transport and Dock Workers Union vs. Mumbai Port Trust, 36. Differential treatment, in our opinion, does not per se amount to violation of Article 14 of the Constitution. It violates Article 14 only when there is no conceivable reasonable basis for the differentiation. In the present case, as pointed out above, there is a reasonable basis, and hence, in our opinion, there is no violation of Article 14 of the Constitution. In our opinion, it is not prudent or pragmatic for the court to insist on absolute equality when there are diverse situations and contingency, as in the present case. In view of the inherent complexities involved in modern society, some free play must be given to the executive authorities in this connection. In our opinion, there is often a misunderstanding about Article 14 of the Constitution, and often lawyers and judges tend to construe it in a doctrinal and absolute sense, which may be totally impractical and make the working of the executive authorities extremely difficult, if not possible. As Lord Denning observed, this power to overturn executive decision must be exercised very carefully, because we have got to remember that the executive and the local authorities have their very own responsibilities and they have the right to make decisions. The court should be very wary about interfering and only interfere in extreme cases. That is, cases where the court is sure they have gone wrong in law or they have been utterly unreasonable. Otherwise, you will get a conflict between the courts and the government and the authorities, which would be most undesirable. The courts must act very warily on this matter. Then, my lord, the next page, in Kesavananda Bharti for State of Kerala. In exercising the power of judicial review, the court cannot be oblivious of the practical needs of the government. The door has to be left open for trial and error. Shama Sutra vs. University of Mysore. Equality before law and equal protection of law is the heart and soul of the constitutional system, adopted by this country. The right to equality and equal protection of law under Article 14 are genus, and the right to non-discrimination are the species. Equality as contemplated under the Constitution means equality among equals. The doctrine of equality is considered to be a corollary to the concept of rule of law, which postulates that every executive action, if it is to operate to the prejudice of any person, must be fair and reasonable to legal authority. What Article 14 prohibits is the class legislation and not reasonable classification. If classification is based upon reasonable criteria and the persons belonging to well-defined class are treated equally, the vice of discrimination would not be accredited. In order to pass the test of reasonable classification, the impugned statute, order, or notification is required to pass the clean test of permissible classification, piece 1, that the classification must be founded on an intelligible differential, which distinguishes persons or things that are grouped together from others left out of the group, and 2, that the differential must have a rational relation to the object sought to be achieved by the impugned statute or order. It is not conceived that the classification should be scientifically perfect or logically complete. The court would not interfere unless it is shown that the classification resulted in inequality amongst the persons similarly situated. The reasonable classification expected to stand the test of the constitutional guarantees requires that such classification was real and substantial, which contemplated some just reasonable relation to the job of the legislation. The courts have not to determine as to whether the impugned action has resulted in inequality, but have to decide whether there were some differentia which had an object to be achieved by the impugned action. Mere differentiation per se does not amount to discrimination, attracting the operation of the guarantee of equality. The purpose and object of the impugned action has to be ascertained from the attending circumstances in each case. For worship here, the petitioner, there are no similarities placed or situated with the private respondents. The private respondent does serve as well as appointed during the COVID period. So the decision of the government to regularize this group of doctors through special recruitment drive does not amount to arbitrariness. Taking into consideration the selfless service that's during the pandemic. So my prayer is that the petitioner does not make out a case for interference of this honorable court. Much obliged.
Yes. It's okay, I think
Chief, I'm appearing for respondent number 5 to 12.
5 to 12 na.
Besides me, more January is also there.
Hmm.
Second, of course, subject to what Lordship says. Can we
How-
continue
how-
tomorrow with a fresh mind?
Okay. How much time will you take? Yes, yes, that one WP 187 also. Who's appearing in 187?
187 about the 7 also. The research scholars, research scientists are. So in the report, more time.
But that research scientist, I think it will be almost the same.
Yeah.
But for 187, it may be different.
Completely without being part of my learned friend, although she doesn't get harder.
Yeah, up to tomorrow, I'm heading to Gauhati in connection with Article 370.
Oh.
6 and 24. So
Final hearing, I
within
hope.
1 hour I can finish maximum,
Okay.
including the editing the judgments.
Okay, then let's continue tomorrow. Ne?
That's
Part third tomorrow. To be continued tomorrow.
Relevant karena markuling na zero problem question dia kumpa. Oh. Jadi soalnya kumpa zero problem question.
Này này cô còn này rồi tôi ngủ nó
Ini lagi dulu. Kita sendiri. Relevant, no?